Good morning, everybody. I'm your host, the Supreme Litigant, and I'd like to welcome y'all back to Smart Loc TV. If you haven't already, you know the routine. Please go ahead and hit that like button, hit that subscription button, and turn the notification bell on. I'll give y'all a second to do that. All right, so today I want to give y'all a secret that I have never told anybody publicly. I only tell this to people privately when they pay me for consultations. Um, this is going to help you better understand um, litigating cases, whether it be a complaint, a writ, a petition. I don't care what it is. It's going to help you better understand it. So I'll jump right on into it. All right. You are a prosecutor. So what do I mean by that? I mean exactly what I say. You are a prosecutor. The same authority that a prosecutor has in a criminal case you have in a civil case, so-called criminal case anyway. You have that same authority in a civil case. This is why if you violate any of the court's rules or court order, they will sanction you and they will dismiss your complaint. Or if you fail to prosecute your case, they'll dismiss it for want of prosecution. So these case laws right here that I just cited, they're going to touch on that. I'm going to read y'all this stuff. And then I have a little small list down here explaining to you, what I mean in a little bit more detail. A court acts in its discretion by dismissing a complaint either with or without prejudice when a plaintiff fails to prosecute his or her case, fails to follow the rules of the court, or fails to follow the court's orders. And that's the authority right there for what they're just saying, for what they're citing right there in this local rule right here. Although dismissal may be an unduly severe sanction for a single episode of misconduct, a court acts properly in dismissing a case when lesser sanctions would not serve the interests of justice. In determining whether a dismissal is warranted, the court considers the effect of a plaintiff's dilatory or contumacious conduct on the court's docket, whether the plaintiff's behavior has prejudiced the defendant, and whether deterrence is necessary to protect the integrity of the judicial system. The court's authority to dismiss a case for failure to prosecute or failure to follow the court's orders is not discarded simply because a plaintiff is proceeding pro se. To be clear, a plaintiff is obligated. To be clear, a plaintiff is obligated. To be clear, a plaintiff is obligated to prosecute his lawsuit in accordance with the federal rules of civil procedure and the local rules of this court. Even a pro se litigant must comply with the federal rules of civil procedure. Let's talk about the local rules right here. So the local rules are what governs internal actions, or so to speak. So like right now, the local rules would not apply to me because I don't have a lawsuit pending in that court. So let's just give an example. Let's say we're in California somewhere. The local rules in California would not apply to me in a particular U.S. district court in California until I filed my lawsuit in that court. Once I file my lawsuit in that court, I need to make sure that I have I've pulled up the correct website for that particular U.S. district court. And then you want to there'll be some captions at the top somewhere. Just click around or whatever, move the mouse around until you find local rules. When you find local rules, click on local rules. There should be a link to that particular court's local rules in a PDF format. Click that, download it, and read those local rules. And make sure you follow those local rules. If you don't, they will sanction your ass. They'll probably give you a warning or two before they sanction you, though, because you're pro se litigant. So they give you a little leeway because you're pro se litigant. Further, the court's authority to dismiss a case for failure to prosecute or failure to follow the court's orders is not discarded simply because a plaintiff is proceeding pro se. Although a pro se plaintiff is afforded some latitude in prosecuting her case, such leeway does not constitute a license for a plaintiff filing pro se to ignore the federal rules of civil procedure, a court's local rules, or a court's orders. This does not just apply in the District of Columbia, in the U.S. District Court and District of Columbia. This applies everywhere. Just to let y'all know. So you got to make sure you're following these rules, y'all. You got to make sure you're following the rules. Plaintiff has a duty to prosecute this action or face dismissal. Plaintiff has a duty to prosecute this action or face dismissal. Plaintiff has a duty to prosecute this action or face dismissal. You are a prosecutor. You are a prosecutor. You are a prosecutor. You are a prosecutor. That obligation applies even though he proceeds pro se. A court may dismiss a case sui sponte for a plaintiff's failure to prosecute or otherwise comply with a court order. So what do they mean by sui sponte? Sui sponte means on its own. It's like a Latin word for on its own, meaning nobody has filed a motion to dismiss. The court is dismissing the action because they're sanctioning you in a sense because you're not complying with the rules. They're going to sanction you. All right. So let's go down here. All right. I spelled this wrong. 1 second. There we go. Number one, here's the rule. These are very simple. If you remember these, you should be good. Think of your causes of actions as claims. This is an insurance claim. All right. This is an insurance claim. This is an insurance claim. You need to get that through your head. This is an insurance claim. So I'm gonna explain something to y'all right quick. When I was going through discovery in my federal lawsuit, I asked, I think I used an interrogatory. I was using interrogatories, I think. And I was requesting any third party or indemnification agreements information from these police officers who I had sued. And they sent me over the information that I asked for. So in other words, an indemnification agreement or something like that. It's like it works just like a surety or something like that. So it was their insurance. Okay. So I'm gonna show y'all what they sent me. I'm gonna pause the video and I'm gonna pull up a link on Google and I'm gonna show y'all what they sent me. Give me a second. I'll be right back. All right. Sorry about that, y'all. Okay. So they sent me the information that I wanted, which was their insurance. Okay. This is that city's insurance company called Alabama Municipal Insurance Corporation. I called this number down here, okay, and I was asking who was over, my case and stuff like that. She gave me the name of the woman. It was a woman, but she said she couldn't really talk to me about the case because these police officers were their clients. They're representing these police officers. All right. So I asked her another question. I was like, ma'am, how many cities and towns do y'all insure in Alabama? And she said just about every single one of them. She told me a number around. She said about 95 to 98% of all cities and towns in Alabama has insurance with this company right here. A city or town is called a municipal corporation. I guess that's why this is municipal insurance corporation. Does that make sense to y'all? This is an insurance claim. Ain't no money, y'all. But this is an insurance claim. So what's going on is you're in a so-called court, but we're not going to call it that. You're in a colorable court. They're using colorable law, and they're using colorable money. Is this making sense for y'all? It makes perfect sense to me because statutes are not laws. Federal Reserve notes are not money. And courts, so-called courts that are created by statutes, are not courts. They're administrative agencies. Moving along. Let's get back to it. Where's that document at? Right here. Think of your causes of actions as claims. You decide what facts to use in support of each of your causes of actions, aka claims. I'm gonna stop right there because I left something out in regards to the insurance claim or whatever. But at my settlements conference, the woman who I was just telling y'all about, not the woman who was on the phone, she was telling me about another woman who represented these police officers or whatever. So these police officers, they work for a city called the City of Chickasaw. The City of Chickasaw has insurance with this company right here. This company right here sent out a woman to my settlements conference who represented her clients. That city, okay, that city, the City of Chickasaw, has insurance for its employees. Those police officers work for the Chickasaw Police Department. I'm connecting the dots for y'all, all right? So this woman from this company was at my settlements conference. In other words, they sent an insurance adjuster to my settlements conference, y'all. I know y'all probably heard me say that before, but I'm gonna say it again. So the insurance adjuster, she's sitting on the side with the police officers. So it's these two police officers, their attorney, and the insurance adjuster. All of them get up, they go in one room, and I stay in the courtroom. And the U.S. magistrate judge, he was like the mediator or whatever. He would come back and tell me what they were offering, and I would say, no, I don't want that. I want this. And he did that probably about 5, maybe 6 times or something like that before we actually settled the case. That's what happened. And I settled the case privately. You're not gonna see that on the record, other than you'll see an order just stating that the case was settled. But you're not gonna who is this? I don't know. But you're not gonna see the non-disclosure agreement, and you're not gonna see the monetary amount that I settled for. All right. But that's what I wanted to say in regards to this is an insurance claim. It's no different than when you're on the side of the when you wreck your car in the middle of the street or something like that. The procedure is a little different, but it's still an insurance claim. All right, look, you decide what facts to use in support of each of your causes of actions, aka claims. You decide that. You decide that. I'm gonna stop right there and I'm gonna show y'all what I'm talking about. Where is this gonna be? Right here. This goes back to this right here. I posted this a little over a month ago on my community section on my YouTube channel. Learn how to plead your case or you may lose. Anything you say can and will be used against you. Courts would not presume that parties have a better case or a better defense than that which they state in their pleadings. The pleader must know how to allege, how to admit, how to deny. And how to deny. Pleadings are the servitors of the court. They pertain to public matters. If they are not clear and certain, if they are not clear and certain, they are useless. They should not be so indefinite or uncertain as to be made instruments of chicanery, surprise, or fraud. 1918, Alabama. Pleadings are taken against the pleader. Pleadings are taken against the pleader. Pleadings are taken against the pleader. So if you plead something in your complaint and it hurts your case, they're going to construe that against you. That's why you only want to talk about stuff what is relevant. You only want to talk about everything that makes you look good and makes them look bad. All right. All of them do this, y'all. This is what they do. If it's relevant to your case, it proves your point. If it's not relevant to your case, it doesn't prove why you're suing them. Do not talk about it. Act like it ain't never happened. And if they bring it up, you just object and say this is irrelevant. And I'm not going to answer it unless I'm ordered to by the court. And then that's when you answer it. Pleadings are taken against the pleader in equity as at law. And there's another case right there. Boom. That is, the equity of the bill will be considered from the facts as the plaintiff has present them. It's the same thing, y'all. It doesn't matter if it's equity or not. It's the same thing. I'm going to read it again. That is, the equity of the bill will be considered from the facts as the plaintiff presents them, and no advantage to the complainant can be claimed from vague and indefinite allegations in his bill. Right now they're talking about equity, because in equity they don't call it a complaint, they call it a bill in equity. In common law they call it a declaration, but it's still a complaint. It functions the same thing as a complaint. And in admiralty proceedings, they don't call it a complaint either. They call it a libel, and whoever files the libel is called a libelant. In equity, they call it a suitor. And I think in common law, they just call it a plaintiff. The plaintiff is, after all, the master of his complaint. This complaint is so important, y'all don't know how many times I'm going to have to tell y'all that. I'm going to go back, and I'm going to come back right here again. I don't know how, I just got to keep telling y'all that. You decide what facts to use in support of each of your causes of actions, aka claims. You decide that. Why do you decide that? Because the plaintiff is, after all, the master of his complaint. It is a well-settled rule that a party is bound by what he states in its pleadings. By what it states in its pleadings. Thus, a plaintiff can plead himself out of a claim by including unnecessary details contrary to his claim. So we're not going to say unnecessary details. We're going to say, thus, a plaintiff can plead himself out of a claim by including irrelevant details contrary to his claim. A plaintiff can plead himself out of court by alleging facts which show that he has no claim, even though he was not required to allege those facts. The pleader must be careful not to allege facts that constitute a defense to his claims for relief, or for that matter, a defense to his defense. I gotta get this in y'all head, man. So I'm gonna do this shit again. You decide what facts to use in support of each of your causes of actions, aka claims. You decide that. Why do you decide that? You decide that because the plaintiff is, after all, the master of his complaint. It is a well-settled rule that a party is bound by what it states in its pleadings. You need to read this again. That complaint is very important, y'all. That's why you need to make sure you allege everything that you can possibly think of when you're drafting it that will support each of your causes of actions. The reason why you want to do this is because courts will not presume that parties have a better case or a better defense than which they state in their pleadings. That's why you want to do that, y'all. The pleader must know how to allege, how to admit, and how to deny. Pleadings are the servitors of the court. They pertain to public matters. If they are not clear and certain, they are useless. The reason why you want to be very careful about what you say in your complaint is because pleadings are taken against the pleader. You can't deny something you pled in your complaint that you didn't do. If you say you punched the police officer in his face or whatever it was, you can't deny it because it's in your complaint. You can't come back and deny it once they try to use that allegation against you, because it's in your damn complaint. You can't deny it. So that's why you need to be very careful about what you say. Very careful about what you say. And you need to be as detailed but brief as possible. Say no more than what is necessary. How you're going to learn what type of allegations you need to make in your complaint is you're going to have to read cases. So let's say you want to, let's say you have a cause of action for false arrest or something like that. So what you would do is, if you're in Alabama, well, let's say you're in Georgia. If you're in Georgia and you got a claim for false arrest, you go look up and do some research, and you type in Georgia elements for false arrest claim or something like that, because each cause of action has elements. All right. These court opinions, they're going to give you the common law elements that you need to allege in your complaint to prove this cause of action. So the complaint, this stuff is very easy, y'all. The complaint part, you're just making allegations. I know they call them ultimate facts, but they're not really facts unless the jury decides them as a fact or whatever, or unless you stipulate to them with the opposing counsel that it's a fact. All right. But you're essentially, all you're doing right now is just making allegations. All right. After you make these allegations, and the so-called judge determines if these allegations are sufficient to justify a cause of action, and you've pled against their qualified immunity defense and any other state law immunity defense or something like that, then you get to go to discovery to get the evidence that you need to prove the allegations in your complaint. That's what you're doing. All right. So let's get to that part right now. All right. You decide what cause of actions, aka claims, to bring against the defendant. Why do you do that? Because you are a prosecutor. You're a prosecutor. You decide all of that based on the facts of the case. So it's just like a grand jury hearing. We're going to say you're the grand jury, all right? And we're going to say you got all the facts. You know all the facts of your case. And you did the research. You say, okay, I got about 5 or 6 causes of actions against them. All right. I think all of these facts are sufficient. So I'm gonna try all of these causes of actions. If you reasonably conclude that the facts justify you bringing a cause of action, whatever cause of action against the defendant, then those are the cause of actions that you need to bring. It's always about the facts. All right, number 3, you decide what evidence. You decide what evidence to use in support of your cause of actions, aka claims against the defendant that you got through discovery. So what do I mean by evidence? This is what evidence is right here. Right here. Testimony, affidavits, request for admissions. So testimony, depositions, interrogatories, requests for admissions, requests for productions, and subpoena duces tecum. I might have left something out too, but if I did, I apologize for that. But generally speaking, this is how you get evidence, by going through discovery. Right here. This is how you get it. You decide what evidence you're going to use and not going to use after you get it. You decide that. Because you are a fucking prosecutor. You need to get that through your head. You are a prosecutor. 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 Get that through your head. And last but not least, you decide what objections to make or not make. And the way you make your objections are, if you're in federal court, you're going to be using the federal rules of evidence. If you're in state court, you're going to be using that particular state's rules of evidence. And generally speaking, the state's rules of evidence and the federal rules of evidence, they're going to be almost identical. They may be slightly different, but they're going to be damn near identical. So how similar they're going to be, let's say, I'm going to give you an example. Alabama is probably about maybe 98 to 95%. I'm not 95, but about 98 to 99% identical to the federal rules of civil procedure. They damn near identical as far as the procedure and the rules and stuff like that. I think I might have left something out. I think I did. I was telling you this is an insurance claim. I wanted to talk about this right. It's a tort too, y'all. By the way, 42 Section 1983 lawsuits are torts. So I wanted to talk about that just a little bit. Just explain to you what a tort is. A tort is an act or omission that gives rise to injury or harm to another and amounts to a civil wrong for which courts impose liability. In the context of torts, injury describes the invasion of any legal right, whereas harm describes a loss or detriment in fact that an individual suffers. All right, so what do I mean? I wish that there's not another footnote. I mean, I can't find this footnote right here, so I'm not going to elaborate on harm. I really don't think this is a good definition for harm, and it kind of confuses me a little without looking at it and reading it. So I'm not going to elaborate on that. What I am going to elaborate on, what is all this stuff? What I am going to elaborate on is injury. Okay, when you see this word injury, they're not talking about you broke your arm, you broke your leg, somebody hit you with a baseball bat, or somebody knocked out your tooth. They're not talking about that type of injury. All right. An injury is the violation of any legal right. So, an example, let's say police officers unlawfully arrest you, unlawfully detain you, something like that, or unlawfully touch you. That is an injury. All right, that is an injury. You need to sue them for that because they violated your right. You have a right to be let alone. You have a right not to be prosecuted without probable cause. You have a right not to be prosecuted on fabricated evidence. All right. So anytime that happens, you have an injury. That is the violation of a legal right to your person, and you need to sue them for that. I don't care if these people take a pair of socks from you without your permission. Sue their ass. Sue them. Sue them. Wherever there's a right, there is a remedy. Wherever there's a right, there's a remedy. You have a right to be left alone. All right. I'm gonna scroll down a little bit more and give you some examples of what torts are. Torts, it really just comes from common law, but they're modifying this stuff. So I'm gonna read y'all somebody just to give you some examples of what torts. Trespass is a tort. Battery is a tort. Assault is a tort. False imprisonment is a tort. Intentional infliction of emotional distress, tort. Negligence. I'm not really sure if that's a tort. I think a contract or something like that has to be involved. So I'm gonna stay away from that from right now. But just generally speaking, this other stuff right here, these are torts. Give me a second, y'all. Let me pause the video. I want to make sure I got everything in this video. So give me a second. Let me pause it, and I'll be right back. All right. Last, I want to say this, y'all. If you would like to support my channel by donations, please send it right here, y'all. This is my Cash App. You can send it right there. I don't care what you send, a dollar, whatever, you know. I appreciate all the donations because I do like to get paid for my time. All right, I'm not going to lie to you. I do feel like I am entitled, to get paid for my time. But if you send me something, thank you. If you don't, still thank you. I just appreciate you watching the video. It's no big deal. So that's it, y'all. You're a prosecutor, man. You're a prosecutor. You're a prosecutor. You're a prosecutor. I don't care if it's a divorce case and you pro se, you're a prosecutor. If you file an appeal, you're a prosecutor. If you're petitioning for a writ of mandamus or writ of certiorari, I don't care what it is, you are a prosecutor. That'll be the end of this video. The Supreme Litigant is out. Peace.